Welcome, everyone. Thank you for coming to our Constitution Day event. My name is Aisha Shafiuddin, and I'm your student trustee of the college. I'm so excited to see so many people here, and it truly is inspiring to me because I'm also here to learn as a student, so it's exciting to see all of you guys here. When my family and I immigrated to the United States and we got our citizenship in 2018, we had a lot of questions on how to become better citizens. And what a better place to do it than here at the College of DuPage. So I am truly amazed and again inspired to see all of you guys here. Our college is a gem, and seeing the people who have worked here for this event, I know the hard work that went in. So I'm excited to see you guys. And I will also encourage you to learn along with us. So obviously we're here to learn about the Constitution, but I will say you all got index cards at the beginning of the event as you walked in. So as you're munching along on your food, feel free to ask any questions on those flashcards, and we will be answering those questions at the end in a Q&A session. Now I'll hand it over to Dr. Caputo, our president, and Dean Rudisell. Thank you all.
My name is Dr. Brian Caputo. I'm the president of College of DuPage. Thank you for joining us for Constitution Day. We are proud to host this annual celebration of a document that details the framework for our country. The theme of this year's Constitution Day is the Supreme Court, the final word. When the Constitution was signed on September 17, 1787, it included Article 3, which outlines the judicial branch of our government and the Supreme Court. Article 3 saw the Supreme Court as an independent judiciary with equal power to the executive and the legislative branches. With the establishment of judicial review, the Supreme Court had the extraordinary power to decide on the constitutionality of acts of Congress. Recent decisions have put the Supreme Court in the spotlight and raised questions about the court's direction. Today's speakers will address the history, composition, and impact of the judicial branch of our government. Constitution Day is a reminder of how civic responsibility plays a vital role in our lives. To this day, the Constitution remains both relevant and powerful. Thank you for joining us for what promises to be an engaging and thought-provoking presentation.
Hello, welcome to Constitution Day at College of DuPage. My name is Mark Rudisell, Interim Dean of Social and Behavioral Sciences and the Library Division at the college. I appreciate all of you taking time from your daily schedules to be here today. 1787, the Constitution of the United States was signed on September 17th, and the celebration of that historical document is celebrated each year on this day. In 1940, Congress and the President of the United States passed an I Am American Day. In 1952, the holiday was renamed Constitution Day, and in 2004, Congress renamed the holiday as Constitution Day or Citizenship Day. The Constitution created three branches of federal government as checks and balances on federal power, federal authority. Each year we examine and discuss an aspect of the Constitution. This year we examined the judicial branch of government, namely the Supreme Court, and we're lucky to have Constitution law experts Maggie Mendenhall-Casey, Supervising Assistant Corporation Counsel of the City of Chicago Department of Law, and Richard Forst, Attorney and College of DuPage Adjunct Faculty of Justice Studies. They're going to discuss the Third Amendment, which formed the Supreme Court, and recent court decisions surrounding Supreme Court itself. So please welcome these panelists, and thank you again for attending Constitution Day at College of DuPage.
Good morning, good morning, good morning. Woo! I was going to say, wait, don't leave me. We are super excited to have you here, and we will be discussing the Constitution. I wanted to first just make a note about our president and the dean of the social and behavior sciences and the library. They are double booked this morning, but they wanted you to know how much they care about this very important event. And you may see them sneak in, so don't be confused if you see them at some point. All right, are you ready to get started? Yeah, you're ready to hear it? All right, let's take ourselves to the Supreme Court, shall we? Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Court of the United States of America are admonished to give their attention to the presenters as they present. God save the United States of America and these honorable members of the Supreme Court of the United States presentation. Attorney Maggie Mendenhall Casey and Attorney Richard Force. We will hear a presentation this morning regarding this honorable Supreme Court of the United States and how did we get here? Thank you.
Hello, my name is Dr. Stephanie Quirk, and it's my pleasure to introduce Attorney Maggie Mendenhall Casey. Attorney Maggie Mendenhall Casey is a supervising assistant corporation counsel with the City of Chicago Department of Law. She advises clients on Freedom of Information Act and Local Record Act compliance. She has represented the taxpayers of the City of Chicago in jury trials, including wrongful death, police conduct, and premises liability. Prior to working for the city, Maggie served as a Cook County Assistant State's Attorney, advocating on behalf of victims of crime. While working as a prosecutor, Maggie tried numerous cases to verdict, including jury trials, felonies, and sexual assaults. She currently sits on the board of the Black Women's Lawyers Association and the Chicago Bar Association Young Lawyers section. The Chicago Bar Association honored Maggie with the Milton H. Gray Award for Outstanding Project Leadership for the 2021-2022 bar year. Please join me in welcoming Attorney Maggie Mendenhall Casey.
I just want to start off and thank you, Dr. Quirk, for that wonderful introduction. And also thank you to you, Professor Force, for bringing me into this presentation. I am so excited to speak with the students here today about the Supreme Court, the Constitution, and the final word, and answer a question for you guys. How did we get from the Constitution we saw on the very first page to the state of the court that we're currently at? And my hope, along with my esteemed colleague, Richard Force, is that by the end of this presentation, you guys will have a sense of how the Supreme Court got its power and how the Supreme Court got to the state that it is today. So in front of you guys, there are 4 sections that we're going to be talking about. The authority of SCOTUS, as we fondly like to call it, the Supreme Court of the United States. Where does the court get its authority to, as in the words of our Chief Justice John Roberts, call balls and strikes? Second, what is the structure of the court? Third, how can the court impact the daily lives of an average person living in the United States of America? And then finally, 4, how did we get here? We'll talk about some more of the topical cases, and again, how that impacts the daily lives of average Americans. Also throughout, be prepared. We'll be asking some questions. We want to keep you engaged and hear your thoughts about the Constitution. So our first question is, how many articles are included in the United States Constitution? Does anybody have a thought about that? You guys can get out loud. 7. Any other thoughts? 3? Okay. Well, it's 7. What's your name, by the way? Zora, good job, Zora, 7. So we're just going to talk about 3, or number 3, which is this next slide, and what really started investing the power in the judiciary. So if you see in front of you Article 3 of the United States Constitution, it establishes a third branch of government, which at the time of the drafting of the Constitution, it was a unique and novel idea to have a branch of government that was separate from the executive or the president and the legislature, the Congress. It was also controversial because it was new. So because of this controversy, because of the fact that a separate judicial body is a novel concept, the framers of the Constitution came to a compromise and basically drafted Article 3, leaving it vague. If you look at the text, it doesn't talk about the powers that are granted to the judiciary. It doesn't talk about the structure of the judiciary. As you see, it doesn't even mention the Supreme Court. So as I was reading Article 3, I was left with several questions. What exactly does that mean? And I wasn't the only one who thought that there needed to be some clarification. We'll turn to the Judiciary Act of 1789. So this was passed in the first session of Congress, and it gave more of an outline as to the powers and the structure of the judiciary. It established that there would be 6 justices in total for the United States Supreme Court, and the Supreme Court was given what we call original jurisdiction for civil actions between states or between a state and the United States. That just means that rather than going to a district court, going to a state court, those entities can bring their questions to the Supreme Court to resolve without working their way up the chain. And we'll talk about that chain a little bit later. The Judiciary Act of 1789 also delineated the way that the lower courts were structured as well, that there would be a district court as well as appellate court that then finally went to the Supreme Court. And that's not the only clarification that was needed. The Judiciary Act, as well as Article 3 of the Constitution, wasn't particularly clear about what powers the Supreme Court has. So now we take it for granted, basically, the Supreme Court can decide what case is following or what law follows the Constitution and what does not. Prior to Marbury versus Madison, that power was not particularly clear. So after the Judiciary Act was passed, President Washington at the time didn't waste time. The same day that the act was passed, he appointed the first Supreme Court of the United States. And within their first term, they heard the case of Marbury versus Madison. And the real impact of Marbury versus Madison is that it really did establish 2 cornerstones of constitutional law that are with us today. First, it established that federal laws that conflict with the U.S. Constitution are invalid. Prior to Marbury versus Madison, that was not clear. It also established that judges are the political entity or political body that determines if a federal law is constitutional or not. We're also going to talk a little bit about the structure of federal and state courts. So you have that diagram in front of you that kind of shows you how a case can get from even the state trial court, which is where I practice, up to the Supreme Court, or from the federal trial court, which is called the U.S. District Court, up to the Supreme Court. So the parties who are not, or a party who is not satisfied with a ruling that they have received from the trial court, from the appellate court, has to petition the Supreme Court to hear the case. And the primary means to petition or ask the Supreme Court to hear a case is to ask it to grant what we call a writ of certiorari, basically asking the court, will you grant a writ to say to the lower court, send the case to us? Nearly all of the cases that are considered by the Supreme Court come to it on appeal. The Supreme Court does have some cases that they have what's called original jurisdiction over, like I was talking about 2 states suing each other, a state suing the U.S. But beyond that, the majority of the cases that the Supreme Court hears really are through appeals. And then here's another graphic for you, just showing how we get from the number of requests up there, 8,000 to 10,000 requests a year, to the end of a term where they're issuing opinions that I believe may be in the low teens of opinions. So if you look at this funnel cone, it goes first off showing cases that are appealed to SCOTUS. That just means people are asking, hey, SCOTUS, will you hear our case? Just because you ask the Supreme Court to hear your case and just because they can hear the case does not mean that they will. So the Supreme Court can issue what's called, as we talked about before, that writ of certiorari, telling the lower court to send a case up to them for review. In order for the Supreme Court to accept the case, we have what's called the rule of four, meaning that 4 of the justices have to agree to hear the case. Not all of the justices do, but 4 do. After there is an accepting of the case, there's briefing, meaning you write out your argument. There's oral arguments. There's a conference where the judges, as well as the justice who leads the judges, or excuse me, the Chief Justice, as well as the other justices, the Chief Justice leading the rest of the justices, discuss the case, debate, take a vote, and then there's an opinion that is issued that is written by the majority. There also could be a dissenting opinion as well, and generally with the Supreme Court, there is going to be a dissenting opinion. So this cone shows you how you get from the 10,000 requests down to the final opinions that we hear come out at the start of summer. Okay, so here's our next question to keep you guys engaged. How many justices currently sit on the Supreme Court of the United States? 9. Okay, I hear a unanimous 9. Professor is proud of you guys, unanimous 9. And we're going to talk a little bit more about that history of how did we get to 9. There is no constitutional requirement, as we saw in Article 3, for there to be 9 justices. So I've thrown up a graphic. The first bar you see there is 1789. We already talked about that. The Judiciary Act established 6 justices. 1807, Congress passed another law, 7 justices. 1837 up to 9. Then you can see rose to 10. Then it shrunk down to 7 in 1866 for political reasons. Congress passed the Judicial Circuits Act and shrank the amount of Supreme Court justices to 7, and this was to prevent President Andrew Johnson from appointing anybody new to the Supreme Court. 3 years later, 1869, Congress passed a new law, then making it 9 justices, and that has been the permanent number going forward. At the end of that graph, we do have a 15 with a question mark. So there was never a change. To this day, 2022, we still have 9 justices. However, in 1937, President Franklin Delano Roosevelt, FDR, did make a plan, what is now called the court packing scheme, to raise the total of justices to 15 from 9. And that was because he was passing New Deal legislation and the courts kept overturning it. So FDR did make a play, did try to get the number of justices bumped up to 15. That failed, and we remain at the 9 that has been in place since 1869. We'll talk a little bit about the qualifications for an individual to reach the Supreme Court of the United States. So some of the qualifications honestly were surprising to me. It does not have a specific age qualification, education qualification, profession, or native-born citizenship. So I guess technically any of us could be Supreme Court justices. We just have to dream enough. But a justice doesn't even have to be a lawyer or graduate from law school, but all justices have been trained in the law. So just a historical tidbit that I found to be interesting. The last justice to be appointed to the Supreme Court who did not attend law school was James F. Burns, and he served from 1941 to 1942. He did not graduate from high school, and he taught himself the law, passing the bar at the age of 23. And also, I think that's a reflection of the change of the legal profession. In the 18th and 19th century, justices studied law under a mentor because there were few law schools in the country. And you see even in certain states such as California that there's a remnant of this tradition. For example, I'm sure a number of you know of Kim Kardashian and how she is trying to be a lawyer without going to law school. That is really a vestige of the apprenticeship role or the apprenticeship process that used to take place for lawyers before there were a number of law schools. We'll also talk about the actual background of the current Supreme Court justices. Just a heads up or a little spoiler, all of them did go to law school. So let's talk a little bit about how Supreme Court justices are selected. So first, the president nominates someone for a vacancy on the court. Then second, the Senate votes to confirm or not confirm the nominee, which requires a simple majority. And then this allows for both the executive, the president, and the legislative branch, the Congress, to participate in selecting SCOTUS justices. Okay, I'm getting to 5 minutes, so I'm gonna start going fast here. So this is the current makeup of our court. The majority of these people either graduated from Yale or Harvard Law. Justice Amy Coney Barrett actually graduated from Notre Dame, but she is the outlier. And you can see here on this graphic, it lets you know what year these justices were appointed to the Supreme Court and which president appointed them. And then we have Justice Ketanji Brown Jackson, the most recent appointment to the Supreme Court, having been sworn in June of this year, and also the first Black woman to sit on the Supreme Court of the United States. We'll talk about the impact of SCOTUS as well. Right here we have a graph talking or showing us that SCOTUS does at times overrule itself or overturn prior opinions. So my colleague Richard Forrest is going to be talking more about the Dobbs decision, which was issued this year, talking about abortion, Obergefell, gay marriage, and some other cases that are reflected on that graph, just showing initial decision on the right, and then on the left, the court overruling itself, overturning itself, deciding that they wanted to set a new precedent. A couple of pictures up there to talk about a real key and pivotal point in terms of the court overruling itself or changing precedent. On the left, at least on the left for me, I would think, yeah, the same for you guys. On the left, we have a picture of Ruby Bridges, and then on the right, we have a picture of some train cars. And I wanted to use these graphics just to briefly talk about the concept of separate but equal, which was promulgated by the Supreme Court in 1896 in response to the Plessy, or in the Plessy versus Ferguson decision. So in that particular case, a Black man wanted to ride on a train car that was marked just for white people. He petitioned to the court and said that this was unconstitutional. The Supreme Court said in Plessy versus Ferguson that it was constitutional to have separate accommodations as long as they were equal. So that was the law of the land until 1954 in Brown versus Board of Education, where the Supreme Court said that separate was inherently unequal. So those are some of the ways that the Supreme Court and their decisions impact the lives of us as daily Americans. And I wanted to put up that picture of little Ruby Bridges, who was so brave and was one of the first people who actually desegregated schools after the Brown versus Board decision. So in this picture, you see Plessy versus Ferguson on one side, and then Brown versus Board on the other side, the court overruling itself. Something else that shows, or sorry, I saw the 2-minute sign, got a little thrown off, but here we go. Another way that the court has impacted the lives of daily Americans is from the Korematsu versus United States case. That was issued in 1944. And if you haven't heard of that case, it was basically in World War II. Internment camps were established to forcibly remove Japanese Americans that were living on the West Coast into camps. Korematsu, who was 23 years old at the time, a Japanese-American man, petitioned all the way to the United States. And the United States, which even our current Chief Justice has said is a stain on the court, decided that the internment camps were constitutional. We have this picture later showing 1998, Mr. Korematsu was given the Presidential Medal of Freedom by then President Bill Clinton in acknowledging the stain on our country with this Korematsu case. And then to end on a lighter and happier note, we have Obergefell versus Hodges in 2015. And this was the case that established that there is a constitutional right to same-sex marriage throughout the United States. On the left, we have a picture of Jim Obergefell and his husband who's sitting in the seat, John Arthur, and they sued Ohio in 2013 after they flew to Baltimore, got married on the airport tarmac, and then went home to Ohio, saying that Ohio's law not recognizing the marriage that they had in Baltimore was unconstitutional. And in 2015, the Supreme Court did establish the right to gay marriage. So this is, an example of the real impact that the Supreme Court has on the daily lives of Americans in the United States and why it's important to remain apprised of the decisions. So I'm going to turn the floor over to my esteemed colleague, Mr. Richard Frost, and he will talk to us about how we got to the state that the court is currently at today. Thank you, guys.
It's still morning. Okay, so good morning. Checking whether it's afternoon or not. I am not Richard Forrest. I'm Dr. Robert Moorhead in sociology here at College of DuPage. It's great to see a bunch of my students out here in the audience. I'll be introducing Richard Forrest. Richard is an adjunct professor of justice studies here at the College of DuPage. He holds a BA from Loyola University of Chicago and a JD from IIT Chicago Kent College of Law. He maintains his own law firm and is a practicing licensed attorney in Orland Hills, concentrating in criminal defense, family law, and bankruptcy law. He's a litigator with over 30 years' experience in state and federal courts, primarily in DuPage, Cook, and Will counties. He's also an avid Bulls, Blackhawks, Bears, White Sox, and Chicago Sky fan. He's very busy with his sports fandom. He has currently married his love for law with his passion for politics, equity, diversity, and inclusion, presenting frequently on these topics. I've seen Richard many times at different campus events, both online and in person. And finally, he co-wrote with Professor Taya Forrest a constitutional law textbook entitled Constitutional Law Comes Alive, An Innovative Approach. Please join me in welcoming Richard Forrest.
Thank you, Dr. Moorhead, and thank you, Professor Forrest. Thank you, Ms. Casey Mendenhall, and all of the faculty that are here. First of all, I want to say Happy Constitution Day. I love the Constitution. Let's get excited for the Constitution. There's so much veneration of politicians in our country. Let's talk about the Constitution. So what we want to do is we want to follow up on what Attorney Mendenhall Casey gave us today, which was an excellent examination of the structure of the third branch of government. But we're going to talk a little bit more about, get down and dirty and talk about how this actually impacts our lives today. So, first question that you see on the screen there is kind of a provocative question, right? Is the Supreme Court capable of addressing the political, social, and racial justice issues before the country? I'm sure all of you have an opinion on that, right? But that's really what this is all about. Is the Supreme Court capable of doing that? So let's talk about how we got here. How did we get here? Let me just grab this clicker and move on. So let's get a little history in first, and then we'll talk about practical stuff. First of all, what you see if you look to the right of that screen are the votes on each of these justices when they were confirmed to the Supreme Court. And you may notice, if you know the dates when some of these justices were confirmed, there's been a trend. And that trend is that the confirmation votes are much closer than they once were. So, for instance, you see near the bottom, Ketanji Brown Jackson, 53 to 47. The Senate voted by just 6 votes to confirm her to the Supreme Court. Oh, and by the way, in just a couple of weeks, the first Monday in October, the Supreme Court will be convening and she'll be sitting on the Supreme Court for the very first time. First Monday in October. Then you also see Amy Coney Barrett confirmed by just 4 votes back in 2020. You see Justice Kavanaugh confirmed a couple years before that by just 2 votes. These were very contentious hearings that were held just in the last few years. But going back a little farther, Justice Elena Kagan, who was appointed by President Obama, that was a 63 to 37 vote. She's known as a liberal justice. That's her inclination. And yet 63 senators voted to confirm her. It was not a close vote. Justice Sonia Sotomayor, also appointed by President Obama, was 68 to 31. And again, a liberal justice, confirmed by a wide margin. Even going back to conservative justices appointed, John Roberts, Samuel Alito, were appointed by President Bush II in 2005. They were confirmed by pretty wide margins, as you see. Justice Clarence Thomas, who is the longest serving member of the court since 1991, his vote was very close, but that was because of a very contentious hearing that you may recall because of certain allegations that were made against Justice Thomas. So let's go on, just giving you a little background there. And let's talk about the case, one particular case, that came before the Supreme Court this year that has been very controversial, and that's Dobbs versus Women's Health Organization, just decided over the summer. You may recall that there was a leak of this opinion that came out a couple of months before the opinion was actually issued. It turned out that the actual opinion was very similar to the leak that was leaked to the press. And we still don't know who did that, by the way. They're supposedly investigating that. But this concerned the constitutionality of a Mississippi law prohibiting abortions after the 15th week of pregnancy. Interestingly, Republican Senator Lindsey Graham is now proposing a law, a federal law, that would basically ratify that and say that throughout the United States there would be no abortions allowed until after the 15th week of pregnancy. Supreme Court upheld that law for Mississippi and allowed states to decide whether abortion could be outlawed, and that overturned 49 years of precedent. You see the reference to Roe versus Wade from 1973, which is the case that first established a right to an abortion under certain circumstances. But actually, it's not just Roe versus Wade, also a case called Planned Parenthood versus Casey, which was from the early 90s, and that opinion was actually written by the first woman that was confirmed to the Supreme Court, Sandra Day O'Connor. She wrote that opinion. That actually was the controlling law until the Dobbs case, the Planned Parenthood versus Casey opinion. So let's talk about a little bit more about Dobbs and what the justices said in their opinions. So Justice Samuel Alito, who was known as a conservative justice, he wrote that abortion is a question of profound moral and social importance that the Constitution unequivocally leaves for the people. And later he said, we thus return the power to weigh those arguments to the people. You might ask, how could those be consistent? But that was his opinion. Then let's go to another opinion. That's the concurring opinion, not the majority opinion, but a concurring opinion by Justice Thomas. And in his opinion, he called for the court to abandon its reliance on what's known as substantive due process. This is a very important phrase for you to focus on, and really that's what my portion of the presentation is about. Justice Thomas called for substantive due process to be abandoned and said it has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity. Now, the thing to remember is this is a concurring opinion. It's not the majority opinion. The other justices did not sign on to this opinion. But Justice Thomas, the longest serving member of the court, I should say, is the one who is putting forth this argument. So what is this phrase substantive due process? Sounds kind of confusing, right? Well, we've got to go back and look at the 14th Amendment. 14th Amendment was ratified in 1868, just a few years after the Civil War ended. In that amendment, it stated that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. And this is the phrase I really want to focus on. Nor shall any state deprive any person of life, liberty, or property without due process of law. And it also talked about denying any person within its jurisdiction equal protection. Also a very important phrase, but not the focus for today. But we want to focus on that life, liberty, or property, and specifically on the word liberty. And that's where substantive due process came from. Justice Benjamin Cardozo, one of the most famous justices ever to sit on the Supreme Court, said in 1937 in a case called Palco versus Connecticut, that the 14th Amendment protects those rights, quote, implicit in the concept of ordered liberty. This is a phrase that all law students memorize. Believe me, by the time they get out of law school, they know that phrase. Some rights set forth in the Bill of Rights must be applied to the states because they are fundamentally important. Now, this is an important concept. This is something that is a theme in our country, which is federal control or rights or obligations compared to state control. The federal and state dynamic is something that has existed in our country from the very beginning and it still persists today, and it drives our debate today, 200 years later, over 200 years later. So what he's saying is that not only do the Bill of Rights apply to the federal government, in other words, federal criminal prosecutions specifically, but also to state criminal prosecutions. This is one of the first times that a justice said that that was the case. Well, this interpretation created this concept of substantive due process. So when we say substantive due process, what we mean is, as opposed to procedural due process, procedural means the actual procedure, the way a case is handled in court or by the police in their investigation, the procedure they have to follow. You may be familiar with the Fourth Amendment about rights against search and seizure. Those are rights that would be considered in the heading of procedural due process. Here we're talking about substantive due process, which is a different concept entirely. It's talking about fundamental rights that people have. So, what is substantive due process? It's the principle in constitutional law that allows courts to protect certain rights from government interference, even if procedural protections are present. So all the things I just talked about. Police did everything right. Courts did everything right in the way they prosecuted the defendant. Not a problem there. However, this is something that is a fundamental right that cannot be taken away. So you see that last phrase there in italics? It says, or the rights are not enumerated, which really means specifically stated, in the Constitution. So if you look at the Constitution, you may look at it and you may say to yourself, I don't see anything here about abortion. Well, that's why this is so controversial. That last part is what has driven the debate for as long as Cardozo said those words. The argument is, in that last line that you see, that last bullet, the argument is that this can result in the functionally unlimited power of review over state laws. States don't like that. States like to control what happens within their borders. They don't like the feds coming in and telling them what they have to do. That's what this is all about. This has been the case since the start of our country to today. It's always been that tension. So, got some questions here. These are actually more like rhetorical questions, if you know what rhetorical questions are. Is the right to privacy, specifically the right to use birth control contraceptives, specifically protected in the Constitution? No. You can go ahead and pull your Constitution out. I think today you're going to get a little pocket Constitution. Take a look. You won't see anything about birth control in there. Is abortion specifically protected in the Constitution? No, it is not. It is not an enumerated right in the Constitution. Is same-sex marriage specifically protected in the Constitution? Nope, it is not addressed in the Constitution. Is interracial marriage specifically protected in the Constitution? No, it is not. There is nothing specifically stated in the Constitution that protects those rights. So how does it happen that they're protected? Well, it's through substantive due process. Let's go back and do a little bit of history examination here. The Lincoln-Douglas debates. Believe it or not, the Lincoln-Douglas debates, which you see on the screen, were primarily about slavery. Actually, they were just as much about states' rights versus federal rights. And from August to October of 1858, I almost said 1858, the Republican candidate for the U.S. Senate, Abraham Lincoln, battled a Democratic senator, a Southern Democrat by the name of Stephen Douglas. Thousands of spectators and newspaper reporters from around the country watched as those two men battled over the primary issue facing the nation, slavery, and a battle over whether that would be extended in the country to new territories coming into the country. A very important debate and a very important issue. Lincoln made a very famous statement at the start of the first debate. He said, "A house divided against itself cannot stand." That bears repeating. A house divided against itself cannot stand. I believe this government cannot endure permanently half slave and half free. What's he really saying? Not just about slavery, he's also saying we can't have a country where the federal government can't tell states what you can do within your state. We can't have that. The states have to submit to federal authority. Otherwise, we're going to have slavery in half the states. And that's not what was intended for our country. It's a fundamental right to be free. Well, just yesterday, Justice Elena Kagan made a statement in a little talk she gave. Oops, did we pay that? I'm sorry. In a little talk she gave at Northwestern. Let me go back. Yeah. So she gave this speech at Northwestern, and she said, if there's a new member of a court, and all of a sudden very fundamental principles of law are being overthrown or being replaced, then people have a right to say, what's going on there? This doesn't seem very law-like. She just said this yesterday. And she's responding to Chief Justice Roberts, because Chief Justice Roberts says there's really no problem here. Just because you disagree with an opinion, that doesn't mean there's a problem with the Supreme Court. You just disagree. She's saying, no. If every time somebody gets appointed to court, again, look at that statement, every time somebody gets appointed to court, then the whole law goes up for grabs, everything we've known to be the law. Remember the precedent from Roe versus Wade, 49 years? That's not very law-like. So we need to ask a question. Remembering what Abraham Lincoln said, right? A country divided against itself cannot stand. Can this country endure as the United States of America, with each state deciding for itself which rights are fundamental for liberty to be protected? So can we exist as a country if Justice Thomas, and let's go back to that because I've got a few more minutes. This is cool. Justice Thomas said, in his concurring opinion in the Dobbs case just a few months ago, he says substantive due process has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity. If that were to be the case, because substantive due process is what established all those fundamental rights being applied to the states. Obergefell, gone. No more same-sex marriage. Abortion, gone. We have already seen that. States are just deciding for themselves whether there would be a right to an abortion. Contraception, birth control, gone. Every state can prohibit it. And even if they don't outright prohibit it, they can prohibit it so that it's only in very limited circumstances. All interracial marriage, gone. Each state can determine for itself whether they're going to allow interracial marriage. So you could get married in Illinois where it's legal to a person of the same sex or a person of a different color. You can go to some place, I'll just pick a southern state, I won't name any, just pick one. You can go to one of those states and they could say, no, here it's prohibited, so we're not going to honor your marriage that you got done in that state in Illinois. This is why this is such a fundamental issue. And this is why Lincoln's admonition to us is so important to remember today. As long ago as 1858, he was saying a country divided against itself cannot stand. That's the issue for today. Thank you.
Can you just join me in giving our presenters another hand clap as they come back to take your questions? I'm trying to encourage them to come take your questions. So I just wanted to say that we are very excited to have this discussion. It is one that we do not take lightly, right? And we want to make sure that we are respecting of one another's opinions and thoughts, but also that it is really framed in the law. So some of our students submitted questions beforehand, but certainly if you have some additional questions that you want to do, to ask of our panelists, you can feel free to do that. I think we passed out index cards, right? So we have people in the audience, or you can speak your question as well. You okay? Okay. So we will have our panelists join us, and we're going to give them a softball question first.
Love a softball.
Right? They kind of came off their heavy educational piece. So we want to start off real slow. We do have some hardball questions for you, though. This is an academic institution, and our students are very much engaged. You should know that. So the first question is, besides the rule of 4, what are the other guidelines for reviewing a case?
I'm sorry, I didn't hear the last.
Besides the rule of 4, so I believe what they're speaking to, and if you can, Josh, put up the funnel slide. How are our cases selected and then decided? I think you spoke to this, Attorney Casey.
Sure. So another thing that the Supreme Court considers in deciding to take a case is, are there different opinions or inconsistencies throughout the appellate circuits? So one, is one court in, for instance, the Seventh Circuit in Chicago saying one thing in terms of the interpreting the Constitution, is the DC Circuit Court saying something else in terms of applying the Constitution. So that's one thing that is considered. Is there inconsistency? Do they believe that this is an issue that is of concern to the American people? As well as we talked about earlier, is this a case that is properly in front of the court? Have you exhausted all of your appellate remedies? Were you in trial court? Did you go to the appellate court? Is this a case that the Supreme Court is legally allowed to hear? So those are some things that are considered. That's the softball? I'm excited to see what's next.
My softball. Yes, no, that was very good. Did you want to add something?
I think that was excellent. I just wanted to add that it really needs to implicate some kind of constitutional provision. Something in the Constitution needs to be in question generally. It's not always the case, but generally, in order for the Supreme Court to decide that they're going to take it. Remember, they have discretion, right? There's 7,000 to 10,000 cases, 8,000 to 10,000 being presented to them. So they need to winnow that down to less than 100. And so in order to do that, they have to basically eliminate everything. The thing I always say is, everybody says, I'm taking this all the way to the Supreme Court. Well, guess what? You could try. But the vast majority of cases don't get there.
Yeah. Our students really had a difficult time with this concept when we were talking about this, getting from this 8,000 to 10,000 down to just the 70 to 100 cases that they hear. So thank you for that. I think as a follow-up, and you sort of hit on this, Attorney Forrest, in your presentation, and you can certainly chime in, Attorney Casey. What does the Supreme Court do if the case they're deciding on has a lot of conflict within society? How do they approach that case?
That's a really loaded question there.
Yeah.
The thing about the Supreme Court is that it tends to lag behind public opinion to some extent, depending on the era that we're in. But in some cases, the Supreme Court is very sensitive to what public opinion is, and in other cases, in other eras in our history, they haven't. So, you'll see, for instance, a decision that was made in the late 1850s, the Dred Scott decision, which, if you read that opinion today, just about any American would be repulsed by the language in that opinion because it so demeans people of color. Yet that was the Chief Justice writing that opinion. So, public opinion of that era was actually pretty consistent with the thinking in that opinion. That decision now is known as possibly the worst Supreme Court decision in American history. So from era to era, that determines whether they're following public opinion or not, and whether they're keeping up with public opinion. Now, the current state of affairs right now, there's an argument being made by those who are not happy with Supreme Court decisions that were just handed down last summer. The argument is that the court is completely out of step with public opinion. And that could be because the court the composition of the court does not necessarily reflect the composition of the country in terms of political attitudes and opinions.
Did you want to add something, Attorney? And then Casey?
Sure. Just a couple of things that come to mind for me. If it's a controversial case, normally it will be one of the last opinions that are issued at the end of the term. I don't know if that's an attempt to build anticipation or why it's done that way, but generally the controversial cases, the ones where there's going to be a 5-4 split, those are going to come out last. And in, I guess, reference or kind of elaborating a bit more on what Richard said, that speaking specifically to Obergefell, so in that case, when that case passed, finding that their same-sex marriage was constitutional throughout the U.S. At that time, 40 of the states, including Guam and I think one other territory, already had some type of provision allowing same-sex marriage, whether that be civil unions, as we had in Illinois, or some other form. So that was really the court being what we would call a majoritarian institution, reflecting the will of the majority. But I think really inherent in the way that the court is established and that people are appointed for life, they're not running for office. Many people are, as we've seen as of late, passing in office. It is really, I believe at least, anti-majoritarian institution in that it's not, they're not responding directly to the will of the people. They're not out for election. And you can see that reflected sometimes in some decisions, even including the recent Dobbs decision.
Thank you very much. I wanted to pivot a little bit. If we have any live questions, I want to take one of those. Does anyone have a live question? No? Where you would speak it out? You do? Okay, we have a mic there for you. Thank you.
Can I just yell? Hello.
You can stand for us, and we would love to know your name.
Can you hear me?
Yes.
My name's Emma, and I was going to ask you a question before I said my question. What was the question that you asked us in the very beginning about the Constitution?
Were you speaking to me?
Yes.
Oh, okay.
You are asking if we can fix something with the Supreme Court.
Oh, okay. Can the court respond to racial, social, and political concerns?
I would like to ask that question to you all.
to our panelists, right? Do tell.
I'll
This
take
is
that on,
juicy.
since I asked
Thank
the
you,
question.
Emma. That was juicy.
Is the court capable of it? I believe the court is capable of it. Has the court done it is very much in question. I think that's really the issue right now. And I think Maggie stated it well, which is, they have lifetime appointments, and they're not susceptible to being voted out of office. So they're not going to be as responsive, just logically, to public opinion, because they don't have to be. They can go with what their own personal preferences are to a certain extent. And I think, so I think they are capable of it, but whether they do or not is another question. But I think that last slide that I showed you on Elaine Kagan kind of touches on this issue when she says that, hey, just because the composition of the court changes doesn't mean the laws change. That's why we have this thing called precedent. It's supposed to be followed. And you may know this, but all these justices, when they come before the Senate for confirmation, are asked this question. They're asked, are you going to follow precedent? Specifically, are you going to follow the precedent of Roe versus Wade? And they either dodge the question or they say, yeah, of course, I love precedent. That's exactly what Justice Kavanaugh said. He said, actually, that's precedent upon precedent. That's the way you put it.
Super precedent.
Super precedent. So, I mean, this is something, yes, we will definitely follow. And then the next thing you know, they're overturning 49 years of precedent. So can they? Yeah, sure, they're capable of it. Will they? We'll see.
I'll hop in there as well. Thank you for that question, Emma, and really bringing us back to what we started the presentation with. You have a good memory. But I agree with Richard. Yes, the court is capable of responding to those issues. What I would note is just to keep in mind that, as we've been talking about, once the individual is appointed to the court, they're there for life. To think about really the process, and we didn't speak much about the political process in this because this is Article 3, this is the judiciary, which is supposed to be removed from politics. But when we talked about the confirmation, in order for an individual to get to the Supreme Court, they need to have a president nominate them, and they need to be confirmed by the Senate, meaning that they need a majority of the votes in the Senate. So that's something to keep in mind as well, that if you might be or someone else might be sitting back and reflecting, how do we get here? How do we get to the court that we have today? It's important to keep in mind that voting and the president you pick has an impact. The senator that you pick has an impact on the court. So yes, the court is capable of responding, but it really does come down to the individuals who have been appointed to sit on our Supreme Court.
Yes, and elected, right? So that's what you were saying, is our election, our vote really does matter. I wanted to pivot a little bit and go to how many women have been Supreme Court justices, thinking of next month. That's a personal favorite for me. How many women have been Supreme Court justices? Maybe we will start off with who was the first woman.
Sandra Day O'Connor in 1981. By the way, she was confirmed unanimously by the Senate, 99-0. In 1981, the first woman to serve.
And that's important because you showed us the little chart, right, of how contentious these hearings could be. But if you think about it, not having a woman until what year again?
1981.
1981, and then having a completely unanimous approach. Another question. Oh, did we get the total?
I can list out. So Sandra Day O'Connor, we have Notorious RBG.
Yes.
We have Kagan, we have Sotomayor, Ketanji Brown Jackson, Amy Coney Barrett. Is there anyone that I think that's it. So was anybody doing a live count? 6, 7? I didn't. 6. Okay, 6.
Yeah. That's a favorite because we always know that there's probably about 120 justices, and only 6 have been women. So whoever asked that question, it was a great question. Will the Supreme Court consider the political climate on highly controversial issues? I think you guys spoke to this, but if you wanted to add anything, you're welcome to do so.
I mean, they say they don't. They say that they do not. They're supposed to be above politics, and that is how they present themselves. So I'll stick with the company line. They say they do not, and that they are above politics. And just as we said, or I said, Chief Justice Roberts likes to think of himself and the court, and other justices as well, as umpires that are really calling balls and strikes, and not looking to politics.
Yeah, the only thing I would say about that is, I mean, if you look at Supreme Court decisions through our history, the era determines the case. I mean, Plessy versus Ferguson, which said separate but equal, was decided in an era when that probably seemed just fine. Actually, that in itself was controversial for the time. The idea of separate but equal was controversial. We're going to give equal facilities to people of color? What? So that was actually very controversial. But Brown versus Board of Education comes along, 80 years later, maybe not that long, 70 years later, and says separate but equal is inherently unequal. And that's in 1954. That, I would not, I'm not quite that old, but I tell you, in 1954, I wouldn't call necessarily the most enlightened era in American history, and yet the Supreme Court is responding to the trends of the time by saying that, what we thought back in the 1800s is that's no longer good policy, and it's no longer good law.
So we have several attendees who believe that if we are unsatisfied with the justices, there's a process to deal with that. So what is the impeachment process for a Supreme Court justice? And just to follow that question up, someone said, I heard that there was a justice who was recently impeached. Why were they impeached, and who was that?
On the process, I would defer to you. Richard, admittedly.
Well, first of all, there hasn't been any recent justice that's been impeached. The only judge that's ever been impeached was in the mid-1800s, Chase. But what's interesting is that no one's ever been convicted in the Senate. Remember, impeachment is a charge. It's like an indictment. It's not a conviction. So you can be impeached in the House of Representatives, which means now you're charged, and now it goes to trial in the Senate. The Senate has never convicted anyone, not even any president. So there's never been an impeachment conviction for either. But there was a judge who was impeached for bribery, I believe. But certainly there have been many who have said, let's impeach on the other side of the aisle, whatever they were deciding. I remember a long time ago, Justice Douglas, a lot of people were very dissatisfied with William Douglas and said, impeach Douglas. I remember seeing bumper stickers that said that. That's how old I am. But yeah, there is no question that there's dissatisfaction, but it just doesn't lead to impeachment. The process itself, though, is similar. If you've paid any attention to the impeachments of Donald Trump that were on the news, it's basically the same process. The House of Representatives takes it up. There's impeachment managers that are appointed. These are members of the House that are attorneys who make the argument and present evidence of why this person should be charged. If they satisfy the majority of the House that the person should be charged, then it goes to the Senate for a trial. 2/3 of the Senate must vote to convict, otherwise the person is acquitted. Very high standard. Not quite the same as a unanimous verdict in a criminal trial, but it's still a pretty high standard, especially when you consider that most of the time our Senate and our House are pretty equally divided. So it's difficult to get 2/3 to agree on anything. But that's the standard.
And to piggyback off what Richard said, thank you for giving us and me that process. I think the first part of the question also was if people are dissatisfied, what can be done. So impeachment is an option under the law. Another thing that I discussed in my presentation or my portion was what some people who are not in favor of it like to call court packing. Others may call it increasing the number of people that sit on the Supreme Court. That is another option as well. So we have 9 justices. We have had 9 justices since the late 1800s. However, all that it takes is to pass a law, just like we passed the Affordable Care Act. We passed, I think, did we pass Build Back Better? An infrastructure bill. A law could be passed to change the number of Supreme Court justices to 1, 2, 3, or 10, 11, 12, 13, 14. So that is another option as well if people are dissatisfied with the rulings from the Supreme Court.
Thank you for that, because I think a lot of terms we use, we don't necessarily speak to. So the packing the court really isn't a real thing. It's an option because there's no constitutional limit. I wanted to go to, this is a really interesting question, and you have to listen closely because there's some statistics involved for my math people. A 2021 poll found that 62% of Americans believe that SCOTUS decisions are driven by politics rather than the U.S. Constitution and the law. So the question is, how much do you agree with this sentiment? And then there's a follow-up.
Well, I'll take that question. My personal opinion, and this is just my personal opinion, is that the current composition of the court is driven by politics in their decisions. I do believe that. I believe that the decisions that were handed down last summer, particularly, were driven by politics, and I think that's what Justice Kagan is responding to in her statement that I showed you. What's happening is that in order to further a political agenda, laws are being upended. Previous understandings of the law, is a better way to put it, are being upended. One of the things I was always taught in law school is that bad cases make bad law. This is a phrase that I remember hearing often in law school. Bad cases make bad law. And what that means is that when you, as a judge, you have a case where you want the verdict or the solution, the disposition of the case to be a certain way because of your own personal preferences, you then twist the law to fit that. That makes bad law, because now that creates a precedent, that creates something for another court to rely on, a lawyer to argue that this is what you said in this case, so therefore it should be applied to my case, Judge. Bad cases make bad law. I would argue that the cases decided this year, Dobbs being one of them, but that's certainly not the only one, are bad cases making bad law.
In response to that question, I think that 62% percentage is interesting and something for the court and the Supreme Court to keep in mind and hold at their heart. Keep in mind that the Supreme Court does not have ability to enforce their laws. They don't have an enforcement body. They can't send police out. They can't send law enforcement out, the Army out to say, you need to follow this rule. We as a country follow the rules because we believe in the legitimacy of the court. We believe that the court has the power and the authority to make these rules. And when you begin getting into the area of people believing, oh, now the 62% that's been quoted, we believe this is based on politics, not based on law. You start getting to an area of concern when you don't have an enforcement body. So that's something to really keep in mind about the power of the court and what people may feel is the politicization of the court.
So I'm going to ask the follow-up question, but I do want our students and our faculty, thank you so much for coming. This is our natural break in classes, so don't take it personal. No. They may actually have to leave and go other places. So we'll give a second. Yes, thank you for your attendance. We'll give a second to allow for this. And sort of you can reflect on how would we insulate from what you guys have determined is really a political version or politicization of decisions. That was the follow-up question.
How would you, can you repeat that question?
How would you go about insulating, if you were advising the court, insulating it from this politicization? I know, right? Not a heavy question at all.
I like that we have some time to think about this one.
I don't know if there really is a way to do that. First of all, Supreme Court justices are entities unto themselves. They're not going to listen to anyone advising them politically, that's for sure. So I would say that I guess my answer would be what Justice Kagan said, which is really reminding Chief Justice Roberts is what she was doing, that, hey, you are endangering the legitimacy of the court. As Maggie said, we don't have any way to enforce our decisions. We have to rely on people following them. In the same way, you can be at a stoplight in the middle of the night, and yet you stop at the red light, even though there's nobody around, no cop, nobody. You still follow the law, and you stop at the red light. That's the way it works with Supreme Court decisions too. And if you're going to make it into a political institution, so it's no different from the House or the Senate or the City Council or anything, then you're throwing us to the wolves. Don't do it. That was, I think, her admonition to the Chief Justice.
Thank you. Attorney Casey, did you want to add, or should we go to a for real softball one?
No, I had some time to think. Now, if you asked me to answer right away, I wouldn't have had anything. But I think what I would recommend is precedent is so important. The idea that we allow decisions, legal decisions, law to stand, and that it's respected. If a decision was made, you make more law following that decision. And keeping in mind with that the caveat that really, if you are going to be breaking with precedent, to be pretty darn sure that it is in line with public opinion. So some precedent we do want to break. We're talking about Plessy versus Ferguson, separate but equal, then Brown versus Board of Education. That's a break with precedent. But that break with precedent was in line with the direction that the country was going in. So that would be my recommendation as a lowly local attorney.
That's interesting because it really takes us sort of full circle. So there's this aspect of not following precedent, and then we recognize that in some instances, you said that the country was moving a certain way. So here's my softball question. Are there term limits for a Supreme Court justice? Are there term limits? No. It is what?
Lifetime appointment.
Lifetime appointment. So I wanted to just make sure that, how can we revert back to the Constitution if that was written in a time where many ideas that are now deemed normal, same-sex marriage, interracial marriage, weren't back then? How can we trust that good old document?
I would say part of this is, and again, we've been talking a lot about Article 3, we've been talking about the judiciary, but part of this is on the Congress as well. I think the court has really reached this level of preeminence in our society because the Congress is not as active. So if people want things done, rather than a law being passed, individuals may go to the court. So I think that the idea of our Constitution being a living Constitution and us having the ability to pass amendments or ratify, amendments or pass laws, that I would hope that there's more active involvement with our government in those areas so that the burden is not completely on the judiciary or completely on the original Constitution. We can amend it and we can pass new laws.
You're okay? Okay. Is there a way a trial case can go straight to the Supreme Court other than a writ of certiorari? That's for my students because they love to say that word.
You get one Latin word in you.
Yeah, well, original jurisdiction would be the answer to that. Maggie talked about that in her presentation, that there are two ways for a case to get to the Supreme Court. One of them is original jurisdiction. Normally, that would be a dispute between the states or a dispute between the states, one state and the federal government. That would have to go right to the Supreme Court for resolution. So
Are there any cases that have an automatic right of appeal to the Supreme Court as a follow-up?
No, I don't think so.
Yeah, you guys know this one. Most egregious criminal.
You mean death penalty cases?
Yeah.
Yeah.
See, I told you they knew.
Okay.
We're getting late. Yes, right? Can attorneys choose which district, and I think what they're speaking of are actually Supreme Court justices, which district they would like, their case to be heard? Can attorneys choose which district court, which would have to be federal, right? Their case can be heard. Do they get to pick and choose?
So I think that questioner is hitting on the concept of forum shopping, and I'll give a typical lawyer answer. It depends. So there are different ways that one might be able to select or go to a district that is more favorable to them, depending upon who the parties are, where the parties are located at, where the incident, if it's based on incident in question, occurred. Those are, ways, especially once you get into a more complex case, that you might be able to look to selecting or have the ability to select a district that is more favorable to you and your client.
Okay. You wanted to add, or?
I mean, forum shopping is in the news right now. I think any lawyer, which is say any lawyer, but most lawyers, I think, who look at what's going on right now with the former president would say that his attorneys have done some forum shopping, and that's why they have this Trump-appointed judge deciding their case on this issue of the special master. So it's definitely in the news. But the thing is, what happens in a lot of these situations is that a special interest will gather a bunch of plaintiffs in a class or just in a group, and then name one of those plaintiffs, the one they want the jurisdiction to be in, as the lead plaintiff. And that allows them to file in a particular jurisdiction. Why would they do that? A lot of times it's not because of the trial court itself, but because the appellate court, the next level. They want specifically the circuit, the federal circuit, they want that circuit to decide. People on the right would not want anyone going to the California, the appellate court for California. That tends to be a very liberal court, at least that's the way it's perceived. Texas would be on the other side. Somebody who's liberal would not want a Texas appellate court, I should say the circuit for Texas, to decide the case.
So last but not least, before we have goodies, because we do have goodies. I don't have them here, but we have them right down the hall. Besides the goodies of the food, please take more food, eat more food, take all the goodies, take all the cookies. Did I mention take everything? We don't want to have anything. Okay, but last but not least, how does one become Chief Justice? Is there a special process for that?
So in a part of the presentation that I had to kind of rush through just because I did have a time limit, the people who become first-off justices and chief justices do have a certain pedigree, a certain resume. Harvard or Yale, then they clerk, which is basically like working for generally a Supreme Court justice themselves. They may go into government practice, working for a White House. So that's how you get your political involvement, because you do get nominated and get to the Supreme Court through a political process. Sometimes going into private practice as well. I think right now what people are looking for in chief justices are people who are young, because it is or relatively young, because it is a lifetime appointment. They want to have the legacy and the impact of selecting somebody that will be there for quite some time. And also they look for people who have been a bit, I think, vague or opaque about some of the most controversial issues. You won't really see much writing from them, much speaking from them on the topics of abortion, gay marriage, things like that that are more like hot button. Those individuals tend to avoid. So the Chief Justice is selected to be the Chief Justice by the President, just like justices are selected. But I think that's about all I have in Richard.
Yeah, that's all I was going to add if you weren't going to add it, is the president decides.
Yeah. So we are kind of coming close to the end, but we do have giveaways for you guys. Since you're here, we have stress reliever gavels, so you can do just what I did, take all of your frustration out. No, it is actually a squishy. So when you're feeling stressed, you can just squeeze, right, the gavel. But we are super excited. We're going to close out with our co-chair for Constitution Day. You ready? Co-chair. Before we do that, can we just really stand, if you don't mind? I know you're ready to wiggle anyway. And give our presenters a hand clap. We are so grateful.
Thank you.
Thank you.
Thank you.
So I am your proctor. Please take out a blank sheet of paper. It is time for your test on everything you've heard today. But seriously, we want to thank our presenters, our panelists. It has been a major contribution. And I want to remind us and leave us with this. First of all, thank you as students for participating, those that are currently present. And also thanking those students who had to depart to get to class on time. That's important as well. Thank you to our audiovisual team. You are critical to the success that we've experienced. And to our overall committee, some of them had to go back and teach classes as well. So we thank our Constitution Committee as far as that. It's been mentioned, please take care of that food that's out there. Take that with you. That seems to be a critical part of this. There will also, do we have to pocket constitutions? Okay, so as in addition to the stress gavel that is available to you, we have pocket constitutions, so you can go back and review and verify. We encourage you, don't just take the word of what you've heard today. Look for yourselves, verify the information that you have. And last but not least, September the 20th, National Voter Registration. If you are not a registered voter, you need to be. You've heard today how important it is. Your vote counts. Everything you've heard today is impacted by you casting a vote. So I encourage you, tell your family, tell your friends, tell all of your inner and outer circle that we need to be involved in our society and social culture. And the way we impact it is by voting. With that being said, that concludes our service today. Thank you all for coming. It has been a pleasure. One last round for our panelists, if we could, please. Thank you. One quick reminder, students, those of you that need credit for being here, you need to verify there's a sign-up sheet outside that is available for you to confirm your attendance in today's meeting. Thank you.